So let's dive in. We've got tons to talk about today. If you're not familiar with the team, my name is Sabrina Schaefer. With me, Phil, you can't do it without smiling. Mr. Phil Milsk, former hearing officer, which if you're not familiar with the process, that's okay. It's just a fancy name for a special education judge. So he has a ton of experience. He's also a policy advisor and writes a lot of the bills and that end up becoming laws for families and special education providers like social workers. And then, of course, my absolute favorite advocate. She's just a rock star. So let's dive in. Today, we are talking about all things discipline in special education, which is a very complex topic. We'll talk about procedural safeguards from a high level today, but we won't go into detail about it. We did a session on your procedural safeguards. If you're not familiar with it, ping us and we'll make sure that you have that session as well. What you should know as it relates to your procedural safeguards and discipline is that discipline is one of the lengthiest sections in the procedural safeguards. It is so important that parents know that parents and children have rights. So one of the things, I know Phil harps on this a lot, and it's coming frankly out of what he saw as a hearing officer. If you're dealing with a discipline issue, and I know he'll talk about this later, you really need to consider at least talking to a very experienced advocate. So I always like to give you the takeaways at first in case you have to jump. First and foremost, you should know when it comes to discipline, no matter what, a student always, not sometimes, there's no caveat, a child always has the right to an education. You can't just suspend a child and say, oh, well, good luck, kid. A child cannot be denied services if they're deemed eligible for special education. By the way, if you don't know if your child's eligible for special education, we have a very short video so you can kind of decipher if you've heard things like your district saying RTI or MTSS, or sometimes we get this a lot. Oh, your child doesn't qualify for special education. They have to go through RTI or MTSS first. Huge red flag. Make sure you check that out. And as it relates to discipline, you must take this away that your child is entitled to a continued education. All right. So like I mentioned, we're not going to dive into procedural safeguards, but I do want you to know what they are because they're really important. It's that packet you get, or you should get, at the beginning or the end of every IEP meeting and some other situations. Effectively, they are your legal rights, protections, and your procedures for children under that federal law we've talked about in the past called the IDEA, or Individuals with Disabilities Education Act. If you're from Illinois, there's a link right here on where you can read your procedural safeguards. Other states have them as well, because remember that IDEA is a federal law, so you have to comply with it no matter what state you're in. So make sure you check that out, because there's nothing that's going to empower you more than reading your procedural safeguards and asking questions. Ask questions. Ask them of your district. Make sure you put them in writing. Ask Judy, ask Bill, ask myself. Ask your friends, make sure that you are asking questions. This stuff is complicated. So read your procedural safeguards and ask questions if you have them. If you don't know what to ask, start there. So let's talk about discipline basics, okay? So school districts are required to provide an education and support to students, before resorting to discipline. And we'll talk about why. There's federal rules around that. There's state rules around that. It is incredibly important because a lot of times this doesn't happen. What we typically see is a child gets suspended. There's no behavioral assessment. There's no support or education that's provided before the child's disciplined, and that is a problem. That should be a giant red flag to you as well. Second, it seems intuitive, but there's more to it. Disciplinary actions cannot be discriminatory. If you're concerned that a disciplinary action has been done in a discriminatory way against your child, there's something called the Office of Civil Rights, or OCR, and you can file a complaint or an OCR complaint among other remedies, right? You have other remedies. We've talked about them. We've got videos on the YouTube channel. That's another option for parents, that you can file that complaint and they do an investigation that really is a very cost-effective way of making sure that your school, your district is in compliance. So with that, let's talk about discipline in special education.
All right. First of all, schools, you know, have a responsibility to provide a safe environment for all students. And that's regardless of students with disabilities. They have to keep it safe, right? We all want our kids in a safe place during the day. You know, there's some misconception out there, but, you know, make no mistake, students with disabilities can be disciplined the same as gen ed students can, but they do have some additional protections. So one example would be if they're suspended for more than 10 school days in a year. You've probably heard that if you have a child who's had any discipline issues. So once a student's suspended for more than 10 days, what happens is that could be considered a change in placement. And so, you know, after that 10th day, and it has to be, it doesn't have to be 10 sequential days. It's 10 days total per school year. So it could be 3 days to, there's some in-school suspension that applies here. And I'll talk a little bit more about that. But when that happens, the district is required to hold what's called a manifestation determination review with the IEP team. Who's on the IEP team? It includes you guys. It includes the parents. And don't ever make that mistake of forgetting that you're part of that team, a very important part of that team, okay? So we're going to really go into depth on those manifestation determination reviews as we go on with the presentation tonight. But the one thing I want you to know, like right top of mind, okay, if you don't agree with the outcome of the MDR, that's how we call them, because everything in special ed has its very own acronym, right? So if you don't agree with the outcome of the MDR, and that's that review of the behavior, parents are entitled to file an expedited due process hearing. And so if any of you have ever been through a due process or contemplated it, it can be a fairly lengthy process by the time you actually get to your hearing, if you do and you don't settle. But under discipline circumstances, you can have what's called an expedited hearing. And that just moves that timeline, you know, it kind of condenses it so that things are happening much more quickly. Because like Sabrina said before, you know, our kids with disabilities are entitled to an education regardless, okay? So that, you know, that is their protection. And then finally, you know, they have to get their services during those days after the 10th day of suspension. So they're entitled to their speech services, their OT, the specialized instruction, all of those things, they have to receive those services, okay? Regardless of the behavior or the incident, they still have to get what's in their IEP. It has to be provided to them. We don't take things away that they get because they're disabled, just because they had a discipline incident, okay? The takeaway from this, an MDR, okay, that's that manifestation determination review, is conducted to decide if the student's disability was the primary cause of the incident in question. Okay, that's the whole purpose of that meeting. They're going to sit there and talk about the child's disability, their IEP, their goals, all of those. They're going to look at everything, and Phil's going to talk about this some more. But and the decision that has to be made during that meeting is whether the disability was the primary reason for the behavior or the incident in question, okay? So that's a really important point. All right, so let's talk about an exception. So we have what, you know, this is another acronym commonly used, the IAES, okay? And that stands for an interim alternative educational setting. So there are times when a child could be removed immediately to a 45-day interim placement. It doesn't happen often. Um, According to, what the law says, the reasons for doing something like that for a district to take that action against a child would be if they had a weapon at school, if they knowingly possess or use or sell a controlled substance. Okay, keyword there being knowingly. Okay, because, a lot of times students with disabilities are, they can be naive and used to do things that they wouldn't normally do and maybe not even know they're doing something wrong. And then the final one is inflicting serious bodily harm. So these are the cases where they could tell you, we're removing your child immediately to an alternative educational setting. That setting is usually it's always a different location where it's frequently a therapeutic day school. Some larger school districts will have their own alternative settings within the district where they, you know, have students who have behavior difficulties or, but it's essentially taking them out of their current placement for a specified period of time. Now, I know this sounds like a, really unusual occurrence, but I will tell you, it's one of my favorite stories actually, and I always have to tell a story. So early in my advocacy years, I had a parent whose child had been removed for an IAES. And so when they contacted me, I was asking questions and the child was a kindergartner. Really? Which of those three exceptions applied here? And what had actually happened was the child threw one of those little alphabet blocks, little wooden block, and it hit the teacher in the forehead just in the right way that she had an open wound. And so the district removed the child, and the district claimed serious bodily harm. So with an immediate removal like that, there's not even enough time, for that, due process hearing or anything like that. And in this particular case, it turned out to be the best thing for the child. The child is still in that placement, and she really was probably not in the right place in the first place. So it all worked out for the best, but you do have to, really be careful and be aware of your rights. And I think, where I'm headed with this is it goes back to, if your child has a serious behavior incident, you need some outside guidance chances. I mean, it's really not a good idea to take these things on alone. It can be very complicated. So
I know we just talked about the MDR. Let's talk about, the manifestation determination review. What we're looking at, remember, is was the behavior a manifestation, the primary cause, as Judy talked about, of the behavior in question? So you're looking at these three things, and we tell you this not to make you lawyers, but I want that little red flag as a parent or as a professional to get triggered when you see this stuff. So I know we like to oversimplify things. It's because it works best for me, but I want this to just sort of get you aware in case you're in this situation. You'd be surprised. You never anticipate it, but then little things like a block. I had a kid once, funny you say that, Judy. He was also first grade or kindergarten years ago. He threw his chair down and got in trouble for that. He didn't actually inflict bodily harm, but like I said, you'd be surprised with some districts, not all, kind of consider inflicting serious bodily harm. So it's important that you know these key considerations. So first and foremost, let's say you're in this situation, your red flag should be alarmed if these considerations come up. Was it a substantial result of the disability? You have to look at the entire child. You have to look at observations, what's been going on, were there other incidences of this behavior? Was it a substantial result of the disability? If yes, you can't discipline like that. You cannot discipline the child as if they were a general ed student. So that's something you're really trying to figure out. Was this really a substantial result of the disability? If it is, it's most likely that the child needs some kind of either additional support or different support. So look out for that. Number two, was there a failure to implement the IEP? We see this all the time where the child gets blamed when really it was someone else not implementing the IEP properly, or a mounting result of a constant or repeated failure to implement a child's IEP. So you might see children who get very frustrated at tests. They don't have their accommodations, and sure enough, they break the pencil. I had one kid, they try to say that they poked somebody with a pencil, and they try to say that was a weapon. And they didn't have the right accommodations, in place. So that's something else that you want to look at. And that's another reason. I know we harp on this. Trust me, it's because I really see it and really believe it. Make sure your parental input is solid. Make sure it's attached to the IEP. Make sure you're speaking up. That IEP is so important. So if the district has failed to implement the IEP, that's another sort of consideration as to why maybe discipline's not appropriate for the child. Another thing we see constantly, if you're not familiar with this term, like everything in special ed, it's kind of a funky name. It's called child signs. High level, there's other resources on it. If you don't have them and you need them, just ping me. I'll send them to you. They're all free resources. Effectively, though, from a super high level, child find is a district's responsibility to find a child, regardless of where they are. So if they're in a private school, if they're homeschooled, or you name it, if a child is within a district's jurisdiction, the district has a responsibility to find children and provide appropriate education to children within their jurisdiction that have special education needs. If the district has failed to do that, that's another consideration to look at in determining whether or not the child's behavior was a manifestation of their disability.
All right. Well, hi, everyone. Phil Milsk, and I'm going to talk about some of the details of what Judy and Sabrina just went through. Believe it or not, there's even more detail. This is a very complicated area, so I'm going to try to make this simplify this as much as I can. So as they pointed out, the MDR is a review process. It has to take place within 10 school days of any decision to change the child's placement because of a violation of the school code of conduct. So keep in mind, the law says they can change your child's placement or to attempt to for violating the code of conduct, which could be, it could be a very minor offense. Codes of conduct cover a lot of territory, and a lot of the things in codes of conduct are not very serious. So just keep in mind, does not have to be a potential criminal violation. It's code of conduct for the school. That's one thing you got to keep in mind. Who has to be on the review team? Well, the parents absolutely have to be invited. And the members from the school district have to include relevant IEP team members. So when I was a hearing officer, I had a case in Southern Illinois where the school district had the following people at a manifestation determination review for a student who had been, who they proposed to remove from the high school because he came to school high on marijuana. They had a school principal that knew nothing about the student's disability. They had a dean of students that knew nothing about the student's disability. They had a school psychologist who had never evaluated the student. The only thing that the school psychologist had done in 8 years of work while the student was at her school or in her school district was to review an 8-year-old evaluation that had been done at a previous school district and then recommend that he didn't need any further evaluations. That's all she did for 8 years. She was part of the team reviewing for the manifestation review. And the other person was a school social worker who had also never evaluated the student. And they recommended that the behavior was a manifestation of his disability. I sat and listened to 3 days of evidence in that case, and it took me 2.5 days to figure out whether the student even had a disability, let alone what it was. And it wasn't until the parent's lawyer called a psychiatrist that they had hired privately to counsel the student that I finally understood what was going on with this kid. So the school had no clue, and they had no idea whether his behavior was a manifestation or not, because they didn't know what his disability was. So you have to really insist that the right people be at the meeting when they do a manifestation. And I actually overturned in my decision, I overturned the manifestation determination that they had made and said that they didn't have the appropriate staff at the meetings. They actually didn't have any appropriate staff that they could have brought to the meeting because nobody really knew what was going on with that student. The other thing to keep in mind is when you have the manifestation determination review, the law requires them to consider all relevant information. So that includes information in the student's records. It includes the IEP. It includes teacher observations. It also includes any relevant information provided by the parent, which could very well be information that is not in the student records. So they can't just go in and say, well, he's a student with a learning disability, therefore this behavior is not characteristic of someone with that type of disability. They have to look at the individual student, his or her diagnostic profile, all the information they have that's relevant, and then make the determination. So keep that in mind, because I have had cases when I was representing students where they would want to just look at the label, the eligibility label, in determining whether it was a manifestation, rather than look at exactly what was going on with the child and all the various pieces of information that should have been made available. There are two questions that the manifestation team has to answer. One is, was the conduct that the student engaged in caused by, or was it caused by, or did it have a direct and substantial relationship with the child's disability? Or the second question would be, and I think Judy brought this up before, was the conduct the direct result of the school district's failure to implement the student's IEP? Those are the two questions the team is supposed to answer. And as Judy and Sabrina pointed out, those are the only questions that need to be determined at this manifestation review. So if they determine, so what happens if they determine that it was a manifestation of his disability, his or her disability? Then they have to either conduct a functional behavioral assessment, or FBA as we call it, and implement a behavioral intervention plan for the child. Unless they've already conducted the FBA, and then they have to look at the behavioral intervention plan and determine whether it needs to be revised. And they have to return the child to the placement from which the child was removed, unless there's an agreement to place the child somewhere else, which there can be. Sometimes there can be an agreement that, I think Judy had mentioned the case where the child was removed and it ended up that particular placement worked out well and parents agreed to leave them there. But if you don't agree on another placement, if there is a manifestation determination made, the student goes back to the placement the student came from. And basically what they've done then is review the behavioral intervention plan or done another assessment to determine whether different interventions need to be need to be utilized. So as we pointed out, and I'll just go over this really quickly, there are circumstances where it doesn't matter whether there's a manifestation or not. And those are the weapon, drug possession or sale, or infliction of serious bodily injury. In those cases, even if there is a manifestation, the student can be removed for up to 45 days and placed in an IAES, alternative educational setting. There are questions. Let's go through this really quickly. There are questions about, was it a weapon that the child brought to school? Judy brought up, I think, in a call we had early in the week or last weekend about some child that brought a pencil to school. Well, there are teachers that are going to tell you that a sharpened pencil can be used to poke an eye out, or to injure an ear, or something like that, or to stab somebody. So, the sharpened pencil argument is probably going to weigh in favor of the school if a child is using it for in order to try to harm somebody. I had a case once where a girl brought a butter knife to school because some boy was bothering her and he wanted her to leave her alone. And we successfully argued that the butter knife was not a weapon because the butter knife couldn't have hurt anybody. So sometimes you have cases where whether the object is a weapon is going to be the issue. In the drug cases, which admittedly I have never had one to litigate, there may be an issue about who possessed the drugs, who sold the drugs, how did the student end up with the drugs, if they had the drugs on them, did they have the drugs on school property? That's another question, because it has to be at school, on school premises, or at a school function under the jurisdiction of the state or local school district. And then the other part of this is, was there serious bodily injury inflicted on another person while on school premises? And that can be a question of fact as well. I mean, Johnny goes to school, gets into a little bit of a tiff in the lunchroom with somebody, shoves the student lands on his rear end, but he's all right, he gets up. Is that serious bodily injury? If the school wants to move Johnny out of the school, there may be administrators that want to make the argument that it was serious. I don't think that is serious, but you're going to get into cases where you may have arguments. There may be a close call. Let me just put it that way about the seriousness. So that's the other part. Two things I wanted to talk about were the expedited hearing, and then there's another rule called the knowledge rule that deals with students who have not been determined eligible for special ed but want to take advantage of these special rules. Let me start with the expedited hearing. So in Illinois, at least, the hearing officers that hear the expedited hearings on discipline matters are the same hearing officers that hear the regular due process hearings. It's just that the hearing officer will be assigned on a random basis to any case that's filed. And if it's a case that's filed and it sounds like a discipline case, our state agency, the State Board of Ed, will consider it to be an expedited request. And I've actually had a case assigned to me that sounded like a discipline case, and it ended up not being a discipline case when you actually looked at what the parent was requesting and the circumstances. So we got it converted to a regular due process, but because the word discipline showed up in the request, the state board thought it should have been the subject of an expedited hearing. So anytime a case smacks of discipline, they're going to make it an expedited case, and that hearing has to take place within 20 school days. There's no exception. That's under the federal statute. So we don't have a lot of the in-depth procedural things going on in those cases due to the lack of time that we do in the regular due process. But you can raise issues, and one of the issues would be you can raise issues about the manifestation review. You can raise issues about the alternative educational setting and whether it's appropriate, because it still has to be appropriate, even though it's alternative. You can raise issues about this. School district can raise issues about whether the student is dangerous and they should be able to remove the student. So sometimes school districts will initiate these cases for due process. And the parent can raise issues, of course, under these exceptions to the manifestation rule, the weapon, drug, serious bodily injury, those issues can be raised in an expedited hearing as well. So that's generally what goes on in an expedited hearing. It is a limited procedure. It's not supposed to take more than 2 days. That's the other limitation. And the hearing officer is supposed to control it so that only evidence dealing with the disciplinary issues get heard in those hearings, so that the decision can be expedited just because of the nature of the proceeding. The other thing I wanted to mention is some districts will utilize a court injunction procedure to try to remove a student based on dangerousness. Usually things involving weapons or drugs, or injury incident, and somebody gets attacked or beat up or assaulted with a weapon. They may go to the local circuit court and try to get an injunction. This comes out of a case that was decided in the late 1980s called Honig, H-O-N-I-G versus Doe. The case out of San Francisco. It was actually the first discipline case that the U.S. Supreme Court heard about IDEA, under IDEA, which I don't even think it was called IDEA at the time, since it was 1988, I think. But anyway, the court alluded to the fact that the district has remedies, and one of the remedies is they can go to court and get an injunction. One more thing that I wanted to bring up. If your child is not yet determined eligible, there may be a way to take advantage of these procedures if you can demonstrate that the district had knowledge that the child probably has a disability. And one of those ways is if you've, in writing, raised issues about whether the child should be eligible. And the other is if a school personnel has raised issues with the district, like a teacher.
Another reason your parental input is so important. That's right? Very true. Exactly. And everything in writing. If you have concerns, email them. Great point. Right. Yeah.
So I'll stop there because we could go on and on forever.
You cover a lot of these that, a child's eligibility category is not the factor in determining whether the behavior was as a result of or a manifestation of their disability. You're not looking at the label, you're looking at the child. By the way, this should be a parallel to everything. We hear this almost every single week where they go, it's very common for children with speech and language issues, or it's very common for, no, it doesn't matter what's common. It's about your child's unique needs. And we've talked about this. So you laid out a lot of the questions that you should be looking at. Some things I want to highlight, you already mentioned, is do you need further observation, right? Has this happened before? What goals does a child have or should have? So those are really good points. So I do want to make sure that we are looking at one other code. This applies to all students. So Judy, you want to walk us through SB 100?
Sure, and I'm going to go quickly, but this is one of those things that happened it passed in 2015, which is some time ago, but it was such a big deal when it happened. I mean, school districts were kind of scrambling to change the way they handled discipline, the way they did things. Parents were even talking about it, which isn't really all that common with, we follow the legislation like really carefully, but it was just a really big deal. And I think, the main points that you need to know, because I still have parents bring this up to me. Well, what about SB 100? I heard this, so you can, get all the details of SB 100 on the ISB website and, any other, through a search engine. But I mean, the biggest thing about it was that it eliminated those zero tolerance policies. So there was, especially for students with disabilities, there was no more of this, it doesn't matter that they had a disability. This was, he had drugs on him. And even if he didn't know he had them on him because somebody stuck him in his pocket and, he's nonverbal and in a wheelchair, he's still suspended, that kind of thing. So it completely did away with that. Districts had to, there were more restrictions put on them for the more harsh disciplinary consequences. They had to really focus on positive behaviors and find ways around, those harsh consequences that kids sometimes faced for, stupid mistakes. And really, what I should have mentioned at the root of all of this, really, it was that school to prison pipeline that was being addressed by this bill. And I have a feeling that Phil probably had something to do with this bill or worked on it. Or
did you write it, Phil?
Just no.
Oh, I did not write this. I do not like the way this bill is written. No, I did not. I knew a lot about it, and I've actually done a couple trainings on it for school social workers. I like the direction that it goes in because it obviously is trying to de-emphasize discipline and re-emphasize education and not excluding students from school unless it's absolutely necessary due to safety, which I like that approach as well. But no, I'm not going to take credit for this one.
Okay.
So one last final topic, because I have been getting nonsense. In fact, I see the Q&A popping up a whole bunch now about interrogating minors, your child, and your parent rights. So just so you know, if there is a behavior and your kid gets pulled into the principal's office or something like that, is there something as a parent you can do to protect your child? Now, this is outside of the MDR. This is when your child gets interrogated, either by the police or school personnel. Parents are required to get notice of potential criminal violations. Now, remember, criminal violation could really be almost anything. So it's a pretty broad category. The other thing is that the school district cannot, including police officers, cannot interrogate a child without notifying the parents first. Now, of course, some school districts have found a way around this. So it's very important that you know about this. If the school district cannot reach the parent or the parent cannot attend, then the district must include a social worker. So what I recommend oftentimes to parents, now remember, this isn't legal advice. I don't know your situation. Breaking Autism doesn't know your situation, so this is not legal advice, but something you might want to consider is providing immediate contact information in writing and what notification means to you and your family, and make sure that's in writing, as well as any concerns. By the way, I know we don't have much time to talk about this right now. If you're not sure how to write those concerns, we have a very truncated video. It is awesome on exactly how you write your parental input and exactly how you make sure that those important pieces are included in that. So make sure you check that out. So let's talk about your resources. First and foremost, I highly recommend all of these sessions. We've got, a video podcast. We've got tons of sessions on there. Go to Breaking Autism on YouTube and check us out. You can also go to breakingautism.com for all things snarky and insightful. You can check us out on Facebook and Twitter, as well as sign up for our newsletter. We do not spam you, I promise. We don't even have time for that, nor would we want to. With that, I know that we're over, so I will hand it on over to you, Shannon.
Thank you all for joining. We really appreciate your time. Thank you.
Sounds good.
Thanks, Shannon.
Thanks, everyone.